Good morning, everyone. I'm Monica from NECA. Thank you for joining us. Today's webinar is on avoiding common pitfalls, what you need to know to succeed as an electrical construction contractor. This class has been approved for 4 credit hours towards your electrical license renewal. You must be present for all 4 hours. I'll be taking attendance through the chat box, and I'd like to hear your voice maybe at the end of the class. It's being held from 9 to 11 today and tomorrow. And today's presenters are John Greenhall and George Pallas, both partners at Cohen Seglius, Pallas, Greenhall, and Furman. And I think first up is John.
Thanks, Monica. Let's go through the instructions for the webinar first. First, I guess I should say thank you all for attending. Up on the screen right now, and if you can't see my screen, please enter something in the question box so that we can see if we can fix that. But if you can take your cell phone and text the number 22333 to the address that's shown on the screen of Cohen Seglius 527, you'll be able to participate in our polling, and there'll probably be 5 to 6 different polls throughout the presentation. This presentation is going to go for 2 days. Today will be an introduction to contracts and a discussion on change orders, and followed by tomorrow will be the completion of different provisions on contracts, and then we'll talk about claims. So just to tell you a little bit about Cohen Seglius, we're a construction-based law firm. We have offices in Newark, New York, Philadelphia, Washington, D.C., and a number of other cities out to the Midwest of the country. We represent public owners, private owners, construction managers, GCs, etc. We like to say we're equal opportunity offenders. Whoever hires us first is the one we represent. And during this presentation, we're going to try to use our own experiences, because honestly, that's the best way to learn, is from other people's mistakes, and try and share that information with you guys as we go through it. So the models for the issues that we're going to raise are really every type of construction project you can think of from a commercial side. While much of what we're going to talk about today could apply to residential projects, most of the time we are focused on commercial. So as I said, the focus of the seminar is to make sure all of you realize what can happen to electrical subcontractors or prime contractors who do not negotiate a contract correctly, give timely notice of an impact, or exclude pending claims from monthly partial releases. The topics of the presentation are going to be changes and different provisions relating to change orders and different scenarios as well, other relevant contract provisions, preservation and types of claims, and project documentation. So before I continue, I just want everyone to know, in the screen that you have in front of you is a box for questions. If it's not open, you can push down on the arrow next to that, and it will give you a list of questions that, or gives you an area to put in questions or comments, which we'll try to address as we go through the seminar. If we can't, we'll try to answer them at the end of each day. So from the perspective of contract negotiation, the main issue is risk allocation. Every owner is going to try to push as much risk down to the general contractor. Every general contractor is going to try to push as much of that risk that the owner is pushing on them down to the subcontractors and so on. Now, certain risks are more properly borne by the owner, while others are more properly with the general contractor. So with regard to the owner, obviously funding, timely payment, taxes, timely decisions, the date of the notice to proceed, those are the types of things that belong to the owner. We also have issues associated with site access, material changes in quantities, and one of the big ones recently with the COVID-19 issue is force majeure, which we'll talk about later. With regard to the contractor, the things that are most commonly put onto the contractor is the adequacy of their price. If it goes over their lump sum price or over their GMP, that's on them. Controlling contingency, the adequacy of the schedule, construction warranties, bonds, if there are any, these types of things, along with safety, are more on the contractor than on the owner. Also, there's a difference between public and private contracts. We're going to be focusing mostly on private contracts today and tomorrow, but you should be aware that many of the provisions are the same. On public contracts, the main difference is you're bidding the job, and the contract itself is usually included in the instructions to bidders or in the bid package, and you're not going to be able to negotiate the terms of that public contract. So once you are accepted as the low bidder, you're going to be bound by that contract as drafted, unless for some reason the instructions to bidders gives you some leeway. On private contracts, the three things that matter the most from an owner's perspective is generally price, and some more price. Yes, the owner is going to look at the quality of the work that's going to be performed or has been performed by the contractor, but from an owner's perspective, and we do represent many owners as well, price is a major consideration, if not the most important consideration. Also, requests for changes to the contract terms are typically addressed. And one of the key things that we want you to take away from this presentation is if you don't ask for a change in the contract terms, you're not going to get them. The more you ask for, the more you're likely to get. I have had a number of different subcontractors who have said to me over the years, listen, they've told us that we can't revise the contract, or that you're dealing with an international CM. They're never going to change the contract. Neither of those statements are accurate. Every CM that I've ever talked to has changed at least one, two, sometimes many provisions, which our clients did not believe they would ever change. So if you don't ask, you don't get. So with that, let's talk about how to be smart, diligent, and play the game better. The way the attorneys at our firm view construction is like a game, and the person who plays that game better is the person who's going to win at the end. The concept being that you want to make sure that all of your ducks are in a row so that if there is a need to go to court, the unfortunate need to go to court, you will be in a better position than the other side who has not played the game as well as you do. So the first issue is always contract negotiations. Why it's critical that a contract is negotiated, because it always starts off with a contract that is drafted by one side and is given to the other. Whoever is the person who initially drafts that contract's in a superior position and has generally drafted it in their favor. And you need to try to even it up so that the risk allocation that we talked about earlier is fairly shared. And the risks that are properly allocated to an owner or to a contractor are allocated in the proper manner. One thing you need to know about contracts is they're written by lawyers. George and I write contracts all the time. We deal with contracts all the time. And believe me, we don't get a lot of clients who call us up, whether they're general contractors or subcontractors, who say, hey, look, make this the fairest contract that we've ever seen. No, they tend to want the contract skewed in their favor. And then as it's negotiated, it moves in one direction towards the middle, but at the same time, you've started off with a better perspective on your side if you've drafted it. Let's see. So there are some important contract issues which we'll address during the webinar. One is paid if paid and pay when paid, no damage for delay, jurisdiction, schedules, notice provisions, and dispute resolution. Schedule requirements, change orders, which is a big one that George is going to be discussing in a little bit. Releases and waivers, termination for convenience and cause, as well as some other items. So in playing the game better, we believe that it's extremely important to be knowledgeable about your contract and make sure your project manager or whoever is running your project know what is in your contract and in your files prior to a shovel hitting the ground. So we've included in this slide deck a checklist for pre-construction, where your project manager or your contract person is going to go through the contract and answer all of these questions. By doing so, they're going to have a very easily accessible list of things to have at their fingertips if any issues arise. These things include your notice to proceed, your substantial completion date, whether or not there are liquidated damages, who notice has to be sent to, have you asked for electronic updates of schedules, etc. By filling this in, you're going to be ahead of whoever else is playing the game, because you're going to know the major issues that are within your contract documents. So let's talk about the types of contracts. So the agreements that we see generally fall into three types. One is a purchase order, one is a standard form, and the other is a company form. So let's talk about purchase orders. Normally if everyone was in the same room, I'd ask how many of you do work based on simply a purchase order, and I've seen one written like this. There are a lot of people who do this. This is a $600,000 subcontract that someone sent a one-page purchase order for. And if you look at this carefully, you'll see that there's a lot more to it than just what's on this one page. So down at the bottom is a note that says this purchase order will be accompanied by a subcontract agreement through the main office. If you never receive that subcontract agreement, do you just ignore that note? The answer is no, you shouldn't, because someone will argue that you're bound by that subcontract, whether you received it or not. By playing the game and asking for that subcontract, you're going to avoid that legal issue. And you're also going to create a document trail that shows that you have asked for this subcontract, and if they don't give it to you, then you can argue that you're not bound by it. This one-page purchase order also adds all the plans and specifications and for addendum. Again, you need to make sure that you've received these types of documents. A nicer looking purchase order for sure, but again, this has its own issues, such as at the bottom where it says see back for terms and conditions. If you don't ask for those terms and conditions, if they're not there on the back, you're going to be bound by what normally would be on those terms and conditions. You're not going to be able to avoid them by simply putting your head in the sand and ignoring them. Generally, I should say before we get away from purchase orders, if you're doing a subcontract where you're actually doing work on site, you should never do it by a purchase order. It should be done by a subcontract. And a purchase order is not going to be giving you enough information to know exactly where your risks lie. Supply contracts by purchase order is fine. But one thing that we have seen is suppliers are getting subcontracts, and a supplier should never just agree to the terms of a subcontract when they're not doing any work on the job. They should always insist on a supply contract. So if you guys are hiring any suppliers, again, you should be using a supply contract or purchase order for the supply of materials. Now, form contracts is the other type of contract. The most common is the AIA form of contract. There are a number of different types of contracts, whether from the consensus docs people, from the engineers, etc. There are a lot of them, but the most common are the AIA forms. Now, the AIA form contract is made up of a standard form of agreement and usually a set of general conditions. If it's a subcontract, you're going to be given an A401, and that too incorporates the prime contract, which will include a fairly lengthy set of general conditions. You should also look to see if the owner or general contractor have added supplementary conditions or addenda to the AIA contracts. Remember, these forms, unless they have the specific AIA copyright information on it, are easily copied and pasted and modified. So never just assume that since it says that it's an AIA contract and doesn't show any modifications, that it hasn't been modified. You need to be carefully reviewing these documents to make sure that it says what you think it is going to say. As you get used to these contracts, you tend to easily gloss over provisions. The change of a few words can have a major impact on the profitability of any job, so you should review them carefully. You also have the ability to mark them up if they provide you with a document. You don't automatically have to roll over and sign it. Most owners and general contractors really hope that every subcontractor just signs it and sends it back. My advice to everyone out there is don't just do that. Again, if you don't ask, you don't get. One issue that comes up a lot with our clients is they get a contract from an owner, in this instance on the screen, and it says this is an A101 standard form of agreement between the owner and the contractor, and all they get from the owner is the A101. What you can't ignore is this language that's on the side of this document, which says that it incorporates the A201, whether it's given to you or not. So in all instances, make sure you have all of the contract documents, all of the exhibits that are referenced in your contract before you sign them. Again, any document can affect the profitability of your job. So it's very important that you grab these documents, review them, etc., before signing the agreement. Non-standard contracts are those that are on the owner or the general contractor or CM's own letterhead. You've seen them many times from the larger construction managers like Turner and Skanska, et cetera. They all have their own form. And who do you think they favor? Of course, they favor, as I said earlier, the drafter. So everything in those non-standard contracts are in the GC's or CM's favor and can say literally anything. So you need to go through those with a fine-tooth comb, and you need to find out what you don't agree with. If you're going to be working with the same CM on a number of different jobs, you should say, look, I'm going to negotiate this once, and let's try to use the same form on each job. And in fact, many CMs now are suggesting using master subcontract agreements, which allow you to do the same thing and spend the time negotiating that, using whatever leverage you have prior to signing it to get it to the best place that you can. Also, make sure that your non-standard contract mirrors your deal. We'll talk about what is called an integration clause later, which basically says if you have any agreements prior to executing this contract, they are no longer applicable. So I have seen situations where I have had a client bid a contract to a general contractor where the scope was X, and they signed a contract where the scope was X plus Y for the same price as their bid on X. That took about a year of litigation before it could get settled. That's what you want to try to avoid. We would prefer that you come with us to questions rather than come to us with problems, because the problems are the things that lead you to spend money in a non-productive manner, where the questions are always productive. So the critical provisions such as scope, payment terms, change orders, schedule requirements, liquidated damages, coordination responsibility, notice, rights for delay clauses, termination, dispute resolution, indemnity. These should all be the first things that you look at when you're reviewing a contract. Make sure that you fill out that document that I showed earlier to give you guys basically a run through the contract. But these items are critical to the profitability of any job. With that, I'm going to turn it over to George to talk about change orders, provisions, and scenarios.
Thank you, John. And good morning, everyone, and welcome to the webinar. I hope you will find it entertaining and also informative. And you can take away a lot of good information that's going to assist you in navigating the pitfalls of construction generally. I'm going to be speaking to you about the changes provision in your contract. And the changes provision is the provision in every one of the contracts that you sign that describes how you get paid for doing work that is not part of the base contract. It's extra work. How do you get paid for it? How do you protect yourself? And that's what we're going to talk about over the next few slides. So, John, did you pass me over to the controls? Because I can't turn this slide. John,
you should have control. Yeah, you should have control. Click on the slides and then try it.
I just did, and it is not. It's not moving. Oh, I guess. All right. So, thank you. I think that was me, John. Is our first poll question?
It appears to be.
Okay. So John and I speak all over the country on these type of issues, and in our industry, we realize it's very apparent that we use the term change order very, very loosely. And so we thought we would start with by asking, what is a change order? Do you agree that a change order is a written request for extra money or time? And using your cell phone, you can pull this question up, and you can then say A for agree or B for disagree. Give you a few moments to do that. Okay. And we can, okay.
All right,
we got
start.
two results. All right, so we have two results so far, and we have a disagreement. Okay. All right. All right, so let's keep moving. Let's keep moving on. Oh, we got some more people coming in. Do they agree? I will tell you that I asked that question literally to 1,000 or more people annually. And about 3% of the people polled get the answer correct. Okay. A change order. Okay, I'm trying to. I don't know why I'm having technical difficulties. I can't pull off the. Yeah, I'm not being able to. I can't pull off the slide, John, to move forward. Okay, it seems like the majority of people are agreeing with it. And I can, there it is. All right. Well, and I apologize for the technical difficulty on my end. The change order is not simply a change of scope or time. It is not that. The AIA defines the change order as a written instrument that is prepared by the architect and signed by all the relevant parties that memorializes an agreement as to the change in the work, the change in the price, and any change in the contract time. A change order is an amendment to your contract. It literally is a legal document that amends your contract. If you do any work in the field without having in your possession an executed change order by the owner, contractor, yourself, the architect, if you don't have that document in your possession, you are performing extra work, but you're not performing change order work. And that's critically important to understand that distinction. So to illustrate and to kind of go through the various scenarios that we can have, I'm going to, hey, John, I'm going to need your help there because it seems like there's a lag with my computer. I'm going to go through 3 scenarios with you. Scenario 1 is where everyone agrees, meaning you and the general contractor or the CM agree that you've encountered a condition in the field that requires extra work. Okay, everyone agrees that it's there. The second scenario, and you agree on the price and the schedule impact. So everyone is in agreement. Scenario 2 is that everyone agrees that extra work is required, but you cannot agree on the price or the schedule impact. And the third scenario is you just don't agree on anything, where you believe that there's a change in scope and the CM believes that it is not. So again, referring back to the first scenario, this is where the owner and you agree that you encountered a condition that's not contemplated by the contract documents, and you both agree that extra work is required. So in this scenario, what is the best practice to do, right? Well, we know that. We know intuitively what the best practice is. You need to notify the owner or the CM in writing of the change condition. And that's important because you'll see later in the webinar that anytime you believe that you have an entitlement to more money or more time, that is defined as a claim under your contract documents typically. And once a claim arises, it automatically triggers the notice requirements in your contract. So when you encounter a change condition that you believe it requires you to perform extra work not contemplated by the contract documents, that's a claim that triggers your notice, so you must notify the CM or the owner in writing of the change condition. You then would price it, of course, you would send in a change order request to the owner for consideration. You'd wait for the change order to be executed by all the parties, returned to you, and then you would proceed with the work. The reason why we say that from a lawyer's perspective is because almost all of the contracts that you're signing, and we see that increasingly commonplace now, it has a provision that expressly states that if you are performing work, extra work in the field, without an executed change order in your possession, that you're doing so at your own risk, and that there's a risk that you may not be compensated for that work if that change order does not proceed and get executed. Now, many of you are thinking, well, wait a minute. If I have to wait every single time on every single job for the change order to be executed and returned to me, every job is going to be impacted and be delayed, right? And that's what everyone on their face will say that's a concern, right? And that is a legitimate concern. And that is something we're going to talk about in a few moments. And it also will take into consideration, really who you're working for. So let me ask these questions. What if the owner requires you to immediately begin performing the change work, but the change order cannot be issued before the work begins? That happens all the time because it may take some time to process the change order up through the chain of command, have it executed by all the relevant parties and given back to you. Are you obligated to proceed with that work? Now, I use the word obligated because in the 30 plus years that I have been doing this work, and John has the same 30 plus years that he's been doing this work, we have not found contract provisions that say that the CM or owner can verbally direct you to do something and automatically that creates a legal obligation on you to do it. So the answer, are you obligated to proceed? The answer is no. You are not legally obligated to proceed. So let's say you're dealing with a contractor, a CM or owner, that's a little squirrely, one that delays responding to your requests, that is really giving you a hard time. You know that if you're asked to do extra work, you have the ability, because you can cite to that contract provision that says you are not supposed to do extra work without a change order in your possession. Otherwise, you run the risk of doing it at your own risk. And you can use that provision to say, I'm not going to proceed with this extra work until I get a change order in my possession. Now, let's say you're working for a client that gives you, 20 jobs a year, that you have a very strong work experience with, right? Are you really going to, from a business perspective, stand on ceremony and not do the work until you get the change order in hand and create some sort of animosity with your favored client, right? That's the issue that you are contemplated. So there are ways to protect yourself while maintaining the relationship with your client. And what you would do, back that up, what we would ask you to do is you would demand that the owner or the contractor provide you with a written directive to proceed with the work upon the agreed upon terms, right? So what you're saying is they've asked us to install a new runway and a raceway, and it's going to, you say it's going to cost $50,000. They agree it's going to cost $50,000. You know it's going to add another 7 days to your schedule. Everyone agrees with it, but the change order is going to take some time to process. So you'll contact your client and say, look, send me a writing confirming that we have a deal to install the raceway at $50,000 with a 7-day time extension. If the owner refuses to do that, and I will tell you, many will do that. They won't send you that letter, right? If they don't do that, then remember one of the most important things you're going to hear in this entire presentation. You, as a subcontractor or as a prime, have a lot of power in yourself. And what we mean by that is you have the power to write your own evidence. So if the owner refuses, or the CM refuses to send you that confirming email or letter, you have the power to do it yourself. So what we suggest as a best practice is, if they won't send it to you and you have a good relationship with your client and you want to get the work moving along and there's an agreement in play, send an email yourself. You'll send an email to your contact at the CM. Dear Bob, this is to confirm our conversation on Monday, in which we agreed that this raceway was out of scope, that you directed me to do it, that we agreed on the price of $50,000. We agreed that it's going to take a 7-day time extension of my contract. We agreed that the change order is being a process will be forthcoming. We are going to proceed with that work on Thursday, unless I hear from you to the contrary. Now, why do we say do that? We do that because when you send a writing yourself to someone else, the recipient of your writing has 3 choices. They could write back to you and say, thank you for that email. I agree with everything you just said. They could send another email instead. I received your email and I disagree with everything that you said, or a part of it. And the third thing they can do is do nothing, not respond. And the law is going to assume that if they do not respond, that they acquiesced and agreed with the contents of the email that you sent. That's very strong evidence to do that. If they write back to you and say, we disagree, that's okay too. Iron out the disagreement. There's nothing wrong with that. And that's how you should proceed with a good relationship, and you feel that you can get comfortable proceeding while protecting your interests. So should a contractor ever make a change in the scope on its own in order to maintain the progress of the work without notifying the owner? Many times when you're out in the field, you'll see you'll look at the review the design documents and it says one thing, and you know that the more efficient and better way to do it is another way. Should you proceed with that work? You know the answer. The answer is no, never. We don't have the design responsibility. That's on the designers. We're responsible for installing what they said. And if there's something that is not correct, we have an obligation to notify them. If we have a belief that we could do it better, then you have an obligation to notify them that of the potential change and why it's beneficial to the project. And the reason why you never proceed on your own is because if you do so, you're going to deprive the owner of its ability to assess that condition and make their own decisions and change the way they want to change it. If you proceed without notifying the owner and getting directive from the owner to proceed with that change, you may have waived your ability to seek a valid change order to do that. You'll be doing it on your own. You may also, your change may, without realizing, may cause the owner to suffer damages that you're not contemplating. So there's never a scenario in which we are going to proceed with the work without first notifying the owner and getting a directive from the owner to do so. Okay. I'm looking at my screen. It does not seem to want to move on me. Okay. I'm sorry. My screen is acting a little funny. All right. So what if the change order has not been issued by the time that you've prepared your next pay application? In other words, you've done the work, you have sent the email confirming it and no one objected to it. Are you entitled to payment? Should you include the open COR on your payment application? That's the first question, right? Now, are you entitled to payment? Well, eventually you'll get paid because you have a valid claim and you have support to get paid. That's true. But you do not have a change order in your possession, and therefore their contract amount has not been modified. So should you include the change order request on your payment application? We believe it's best practice to do so. We think it's good that you do that. And the reason we want you to do that is because we want to make sure that the owner or the CM is fully aware that you are seeking a payment for that extra work, and it satisfies a notice requirement and keeps track of it. And I'm trying to change my screen again, and somehow it's blocking. Okay. So the best practice is then to treat the written direction as a change order directive, a construction change directive, as we'll discuss a little bit later. But we recommend strongly to identify the changed work on the pay application. But keep in mind, do not modify the first page of your pay application to reflect an adjustment in your contract value for doing this work. It will just simply delay the processing of your payment because there's not been a change order issued, and therefore it's going to all of your front page analysis of the adjusted contract amount and earned to date will be thrown off. So make sure that you identify it in your pay application, but not on the first page, adjusting your values. So before signing the change order, because now finally has come, right? You have to ask yourself these few questions. Does the change order cover all the costs to perform the extra work? Does it include the change in time, the extension of time that I had requested? Or does the change order account for any delay or impact or extended general condition costs that are needed, right? These are all the questions that we have. So if the answers to any of these questions are no, then we have a potential problem. And the reason why I say that is because many times the change order may not cover all of the costs associated with the extra work. And the reason why I say that is because when we price extra work, many times it's common to price out the labor, the materials, and in the supervision, but we're not factoring in the extended general conditions that may be incurred. So that's something that we will need to take a look at. It's also very possible that we ask for 10 days for a 10-day time extension, but they only give you 7, right? Or some other amount. So what do you do in the event that the change order and those questions are answered no? On the face of your change order, you must reserve your rights. If you don't reserve your rights, the law is going to assume, and the contract itself is going to inform, that's considered a release. So when I say reserve your rights on the face of the change order, I mean literally on the copy of the change order, you need to state specifically that you are going to reserve your rights for the items that are not accounted for. Okay, I'm going to excuse you 1 second. I apologize for that. My neighbors have their landscapers out and they're cutting the grass. Oh. So when I say that, you have to put it on right on the face of the change order, and by doing so, that'll give you an opportunity to reserve your rights. Right? The contract language is important because the execution of the change order itself will be considered a final and binding resolution of that scope of work. If so, that is why you must reserve your rights on the face of the change order. And so here is a potential change order request, and then also you'll see on paragraph 7 that on the acknowledgement that many change orders on their face will say that the compensation in the change order constitutes a full and final compensation due to you for this work in place. So if the change order that comes back to you is a little different and doesn't include everything that you had requested in your change order, then that is something that you're going to have to reserve. So, for example, what we'll do is, okay, that's the acknowledgement form. So we can include language, for example, if there's a delay component on the change order, that this change order excludes all delays and inefficiencies and disruptions, and then you'll seek to get that later at a later date. And what we've also included for your for benefit is a form.
George,
Yep.
I have a question for you. What if nowadays everybody's using computer programs where they're holding all of the project documents and there's no way to modify the change order?
Right. Then if the contract project is now run all by computer, by the computer software programs, you still have to make that modification, and the only way to do that is by sending it a letter, and you have to send that letter by indicating here's an example of it. It's a form sending a letter saying that you're incapable by use of the software to amend the change order. However, we are still reserving our rights for any of the items or rights that you're seeking to amend. And this is a formal letter that we have in front of you now, can be modified to account for that condition. But you can see from this reservation letter, what we're saying is, we say, as you know, the change order request contain this notation, or we sent you a letter, because letter to reserve our rights. And it's important because many times what you'll encounter is, if you try to modify your change order, it's very possible that the general contractor or owner will not process the change order. And that is a circumstance in which they're trying to push back to you. And now you're faced with a dilemma. Do I sign the change order as is and give up the rights? Or do I not sign the change order and not get paid for the work that I performed? This form of letter here also gives you an ability to protect yourself, because what it says is, the change order request contained a notation that to reserving your rights, and that you as a subcontractor were advised that change order request would not be processed with that language included. So what we recommend is that we sign the change order as is, but send this letter, because what we're saying in the letter is that notwithstanding the fact that you would not sign the change order with the modification, we are nonetheless reserving our rights in connection with that change order. And the reason why it's important to send this letter along with and simultaneously with the executed change order is because the law assumes that if you had sent it in, that if you sign the change order as is, you will in fact waive those rights, because a waiver is a conscious, intentional act, and the law is going to interpret that your review and signing of that change order constitutes an intentional act to waive your rights. This letter, sent simultaneously with the change order signed, is evidence that you did not waive your rights, right? And it gives you the best argument to make that the contract change order was not waived and all of your rights are preserved. And that's what we would recommend that we do. Okay. So why is it important to get a fully executed contract? And if they don't do that, if they don't sign the modified change order, what do we do in those cases? Well, it's always the same thing, right? We always are working on protecting our interests by using our own fingers, by writing letters to the CM and the owner or the owner to preserve our rights. So why do most cases involve extra work being performed without a change order? Because most people contractors are actually trying to pursue the project in a efficient manner to keep the project schedule going, and that's why they do that. Well, what are the best ways to avoid this from happening? Do you proceed with the work? What about leverage? This is scenario one where we are all in agreement, right? We're all in agreement that the work is going to be performed, and we have an understanding of the terms of that extra work. The way to best protect oneself is always by the writing. So when we as lawyers will tell you, if you don't have the change order, the contract provides you protection not to proceed with the work. The business hat on our heads says you can still proceed with work provided you take the necessary precautions to protect yourself, which would include sending the letters, memorializing the terms if they won't do that for you. And that's what's critically important. And if you do that, if you memorialize that in writing, you have a very strong chance of getting paid in the event that the change order ultimately never shows up. So let me move to scenario number two. Scenario number two is a situation in which both you and the owner or general contractor agree that you have encountered a condition not contemplated by the contract documents, and extra work is required. So everyone agrees that extra work is needed. But the problem is you and the owner or the CM do not agree on what the change in the contract price is or the contract time. You say it's going to cost $50,000 and 7 days of time. And the CM says, no way, it's not worth more than $30,000. And it's only maybe 3 days of time. So what do we do under those circumstances? Well, the mechanism under the changes provision to account for that is the construction change directive. And a constructive change directive is a written form that's signed by the owner or the general contractor directing you to perform extra work, right? And it leaves open what the cost is and with the time impact for a later date, okay? So why is it important in this scenario for you to receive a construction change directive? The reason is in the second bullet, because it is an acknowledgement that what they're directing you to do is extra work. And the reason why that's so significant is because when you're in the honeymoon phase of the relationship, yeah, everyone agrees we can work through a lot of these issues. But in the divorce proceedings on the back end of the job, now all of a sudden we have a problem. And if they don't want to pay you for this extra work, the CM is going to find every possible excuse not to pay you, including looking at an obscure note on a demolition drawing and somehow trying to tie you to that note, or on a reflective ceiling plan, or a landscape drawing, or a plumbing drawing. And the reason why I'm using these extreme examples is because in most of the times your contracts incorporate all the drawings on the project and the specifications and the owner's contract with the CM, and they're going to hook some obscure reason to tie you to that work to argue they don't owe you anything for that work. And the more times they can throw up a roadblock to you, the value of your claim comes down. It just comes down. So that's why it's critically important for you to receive, in that scenario, a construction change directive. Here, the AIA defines a constructive change directive as a written order prepared by the architect and signed by the owner and the architect directing a change in the work. And that's why it's such a critical document to get when you have a scenario where extra work is required, but there's not an agreement as to time or money. So that leads us to our next poll question, which is, if you get a CCD, what should you do with it? And we have A, B, C, D, and E. I want to take a few moments to see whether you can type in your poll responses. And I think you are not responding to the poll questions because you know that this really was a, oh, here you go. We have a few people coming in. All right, so let me see if I can move along. And I see that most people said they proceed with the work. That question really is a trick question because it depends on the language of your contract. And that's why it's very important as to what John said earlier, why we need to review our contract documents to understand we understand the process of getting these extra work items done. And the reason is because the AIA paragraph 7.3.9 of the general conditions does, if it's included in your contract, may allow you to seek payment for construction change directives from the owner as you're processing the work. However, the most typical scenario is the owner drafted contract which says you are not entitled to be paid for doing that work. So when you get paid until the work is complete and a change order is issued, that's what normally happens. So another question I want to ask you is, do you think is it wise to sign a CCD when you get it? We say the answer is no. And I'll give you an example of that. Many times, for example, in a scenario I gave you, you said it was $50,000 and the CM says it's $30,000. They may issue you a CCD that says proceed with the work, but not to exceed $30,000. Now, you may interpret that to mean, well, when I get to $30,000, I'm going to stop and tell the CM where I'm at and then try to get that negotiate the balance. The CM is going to interpret it to mean you just agreed to do that extra work for a price not to exceed $30,000. So there is no reason for you ever to sign a CCD because it could be interpreted as a change order, and that's not something that you want to do. So another thing that we need to understand is, what are we entitled to be paid when doing this extra work? Most subcontractors fall down here because you don't have a change order and you're proceeding under a CCD, you have to keep track of your costs in order to create and provide the evidence necessary to back it up. And let me speak to that. And before I get to that, let me ask you another question. What if the owner refuses to give you a CCD? You agree to this extra work and you contact your person and say, okay, give me a CCD, I'll get moving on it. And they say, look, I'm too busy for that. Why are you bothering me with that? And say, well, I went to a seminar with George Pallas and John Greenhall. They told me to get a CCD from me. And they respond by saying, what are you talking about? We agree it's extra work. It's obvious. I don't have time for this. Keep moving. Just like we talked about in scenario 1. If they refuse to issue the CCD, you have to prepare a writing to them. Dear Bob, this is to confirm our conversation on Monday. in which we agreed that this work was in fact beyond the scope of the base contract and is considered extra. While we disagreed as to the value of $50,000 or $30,000, we are going to proceed based on a directive and consider our conversation a construction change directive to proceed with that work. I'm going to proceed with that work on Thursday unless I hear from you to the contrary. And again, just as in scenario one, when you send that email to Bob, he's got three choices. He either writes back and agrees, he writes back and disagrees and disputes the conversation, or he says nothing. If he writes back and agrees or says nothing, you have very strong evidence that there was a meeting on this particular Monday, there was a conversation with the appropriate parties, it was memorialized in writing, and it was not objected to. And that's how you protect yourself, and if you can't get the CCD from the owner with CM. So let's assume for a moment you got the CCD, or this letter was sent out and not objected to. How do you get paid? How do you get paid? So the best practices are, it's very important that you're able to effectively, accurately, and efficiently track your time and the impact of your project schedule. So we recommend that you should create new cost codes in your job cost reports that separately, and that's the key, separately track the extra work being performed pursuant to the CCD. It's equally important that you notify your superintendents and foremen that when they track their labor hours in performing this work, that it identifies the work that's being performed pursuant to the CCD. Your schedule should also create a placeholder in your schedule so that you can track all of the time impacts associated with performing this work. Now, you've got the CCD, you've set up all your cost codes. How are you going to keep the owner updated on the progress of the work and the fact that you are in fact incurring costs and time? How do you keep them notified of that? What is the mechanism? Well, we know the mechanism. We're going to have T&M tickets. But let's talk about T&M for a moment. We know that intuitively it means time and material. Material is one thing, that's great, right? We know what the material is. But what's the value of that time? Now, as union electricians, we're thinking, well, it's the union rate. That's what the rate is. Well, what if this is not a prevailing rate job? It's a private job, and you're working on it. And there's now a disagreement with respect to what the value of your hour is. Do you have attached to your contract the labor rates for all of the various level of personnel, from your apprentices, your laborers, your journeymen? Do we have all that? Because if not, now all of a sudden, if I'm in the divorce proceeding with you, you and I may have a disagreement. You're thinking it's the union scale. The owner may be thinking, well, no, it's something a lot less than that. So it's a good habit and good practice to make sure that there's no disagreement as to what the labor rates are. So when we talk about T&M tickets, we all know what the T stands for and the value of that T. So what is a T&M ticket? Well, it's a form, right? It's a document. It's a written document that's out in the field with your superintendent or your foreman. That's filled out every day and contains certain information. So what information should it include? Well, it should include the date, right? It should describe the work that you're doing, the man hours being expended, the equipment, the supervision, but it also should identify where the work is being done and what work is being done specifically. And let me tell you what I mean by that. Let's assume for a moment that the scenario we've been using is installing an additional raceway. But let's say on this project, there are 4 other raceways. And you're being asked to install a 5th one. And in your ticket is described install raceway. That now leaves me as the CM or the owner an opportunity to challenge you on that ticket. I don't know what that ticket's for. It said you were installing raceway. But how do I know it's not base contract? How do I know it's not one of the other 4? And now you're left with trying to explain your schedule when the other ones were installed. And now we have an issue. And every time I can create an issue for you, that value of what you're looking for goes down because you want to compromise it. That gets eliminated if it's very clear on the face of the time and material ticket. June 3rd, 8 men, 5 hours, performing, installing raceway pursuant to CCD number 1. That's all that needs to be said. And that will give you another way to play the game better by allowing, making it very clear from the ticket what the work is being done, right? So now, I think, oh, let's see my ticket. So once your foreman is in the field and he's got the ticket and he fills it out properly, what are you asking him to do or her to do with that ticket? Now you're going to say get it signed, right? You're going to ask for someone from the CM to sign it. Who signs it on behalf of the CM? Who are you having to sign it? Now, most of you, if you were in a room together, you'd raise your hand and say, well, I'm going to get the representative of the CM in the field to sign it. Well, why do you assume that to be the case? Did your project manager review the contract and then to assume and to find out who was authorized on behalf of the CM to sign the ticket? That's an important query to have, because if you don't know and who has the authority, and it's not clear as to who has the authority to sign the ticket, then you leave me with the argument to say that the individual who signed the ticket on behalf of the CM was not authorized. And now you're going to say, well, he was authorized because he was on the job and he was conducting the business. And then we have a dispute. Now we're back into that dispute again. So make sure it's very clear who is authorized to sign the ticket. Now, many times, owners or CMs will sign the ticket and they'll stamp it. And they'll stamp it with something that says to the effect, this is to verify time and material only. Now that leads us to the next poll question. Do you care about the limiting language on the stamp? So what should you do? Should you cross it out? Should you fix it by modifying the stamp, or don't worry about it? Let's take a few moments to answer this poll question. Okay. So I see that we're pretty much split. Most of people saying yes, but we can fix it by modifying the stamp and initialing it. Okay, and then we have someone who voted no. So let me move on. The answer is no. Should you care about that stamp? No. And I'll tell you the reason why. The stamp is critically important because it verifies that on June 3rd, you had 8 men working 5 hours installing raceway pursuant to CCD number 1. And if they stamp it and sign off on it, they can't, during the divorce proceedings, ever question that you in fact had on June 3rd 8 men working 5 hours performing that work. It's an admission. That's why it's critically important for you to get that thing signed and have them verify it. So let me change the scenario. Let's say the stamp says, this is to verify time and material only, but thank you, I'm never going to pay you for the work. I don't care. It doesn't matter what the stamp says. What we need is a verification from them that the work was performed that day. Okay? And that's what we need them to do. That's what we're looking for. We want the right person signing it. They're going to stamp it. It's common in the industry, and it's of no concern as long as they're verifying that on that day, the ticket accurately reflects what was done, the hours being performed, and that it was done pursuant to a particular, in this case, CCD. Because they can't, and the reason is, as I laid out, you cannot dispute the accuracy of it, and that's why it's so important. But let me ask you a different question. What if the owner or its representative refuses to sign the ticket? Right? What if they refuse? So you're a guy in the field, comes in there and says, "Hey, Bob, I just did this. I'm doing this work today, and here's the ticket. And Bob says, wait a minute, I went to one of these seminars, and I know that I really don't want to sign anything, so I'm not going to sign it. And he's backing up, his hands in the air, backing away from your superintendent. And your superintendent is chasing him with the ticket. They call your project manager. What if they refuse to sign? What do? They won't sign it, they won't stamp it. Now what? That happens often on jobs. Well, look, the first thing we're going to do is we're going to say, look, we're going to try and inquire, why aren't you signing it? Let's try to resolve this issue in the field, right? And it may be because they're not signing because they don't agree with the contents of the ticket. Okay, well, let's work it out. Maybe they don't think you have 8 men, you only had 7. Well, all right, we'll figure it out, work it out. But if they just are refusing to interact and to resolve the issue with you in the field, then what do? What do you do then if they refuse to sign? Once again, we have the power. And it's always something that I always highlight to when we speak to subcontractors is we always have the power. What do you do next when that happens? You are going to send that ticket back to your home office, and you're going to then send it by email or mail to the general contractor. We recommend that it's done on a every day, every other day, certainly no longer than a week, right? Why am I telling you to send that ticket to the CM? Just like in scenario 1, when you send something in writing to another party, they have 3 options. They have 3 options on what to do. They can accept it, they can reject it, or they can be silent. And that's what's so important. So, okay, let's see, that's there. All right, so what are the best practices? John, can you give me the 67? Okay, so you send that to your home office, you compile it, you put it together, you send it into them, right? If they do not dispute it, they own them. Now, you can't wait till the end of the work is done, then compile all of your tickets and mail it in. And the reason is because the law is going to assume that it may have been doctored, right? But if you send something out contemporaneously, you did the work, you prepared the ticket, you sent it in, the law is going to assume that the ticket accurately reflects what you observed, what happened. When you send it to the CM and they do nothing with it, it's now they own it. So many times subcontractors will complain that they have a problem GC, they're not signing tickets or stamping. We have the power. Subcontractors always have the power. If they don't sign it, they don't stamp it, no problem. Give them the ticket. You can do what you can do to control yourself and play the game better. They don't want to sign, no problem. Here's my ticket. I sent you by email. I'm attaching it to you. If they don't complain about it, then they own it, right? And that is always the case to do that. Now, you also on larger projects or for larger CCDs, you should also make sure you prepare a schedule impact analysis to make sure that you're keeping track of what the impact of the schedule is for you. And that's something that needs to be done because the T&M ticket itself isn't going to be enough necessarily to support the impact of the time, right? It's not going to create any kind of analysis on the ticket, but you need to make sure that you keep track of the ticket and why it is important to get them submitted. So now, once all the tickets are done, the question is, how do you get paid? How do you get paid? Well, at the end, the work's done, the tickets were prepared, accurately describing the raceway that you did pursuant to CCD number 1. They were either signed, they were either stamped, or they were neither, but you mailed them in every other day or every day. They have them. You pile up all your tickets, and you prepare a change order request to submit to get paid for that extra work. But what if your tickets add up not to $50,000, but they add up to $65,000 with your markup? Are you entitled to $65,000 or $50,000? You're entitled to $65 because you offered to do it at $50. They said no. On the same token, the tickets add up to $35,000. Are you entitled to $50,000 or $35,000? You're entitled to $35,000, right? You're doing this on force account. So under that scenario, just like in scenario 1, where there's extra work being done, irrespective of what the general contractor does, we have power within our fingers to document and memorialize those terms that are needed for us to get paid for doing all of that work, right? So CCDs are a magical form. There are forms, of course, but there's nothing magical. It's a directive for you to do extra work, and that's why it's so critical. So when you encounter a condition that you're asked to do extra work, you want to make sure that you either get a CCD or you confirm in writing with your client that the work that's being done is in fact extra. You want to nail that down while you're in the honeymoon stage in the field and memorialize it in writing. The CCDs are always tricky. They're tricky because the CMs try to play games with them. They put a not to exceed price in there. They ask you to sign the CCDs because they're trying to lock you in. They may not issue you a CCD, in a formal context. What's a written directive? A written directive is, what that is. It's something. It could be an email or a letter from them directing you to do extra work. But you have to make sure that that documentation, either from them or from you to the CM, clearly identifies the work that's being asked to be done and clearly sets out that the work that you're being asked to do is in fact extra. So now that the only thing that's not in dispute anymore, that the only thing that we're fighting or going to resolve later is the impact on the schedule and the cost. And I will tell you that we represent about 1,000 contractors, and this happens all the time where subcontractors do the extra work, but because and they're great at it, but what they fail to do is they fail to properly document the costs that are being incurred and memorializing that through the T&M tickets and the job costing, so it's segregated out and you can isolate it. Because the number one thing that John and I do when we receive these claims, and we're on the other side of the sub, is we scrub the documents to try to fashion the argument that this work that's being done that they're claiming was really base contract. And the more we can do that, the more of the value drops because you want to settle it. And that's what the game is that they will routinely try to play. So let's move to our next scenario, which is the final scenario, scenario 3. And that is that you encounter a condition which you believe is extra, but the CM and owner believe is not. They believe that you own it, that it's your scope. Now, when that happens, that they're not going to issue you a change order, right? Because there's no agreement as to scope and time. They're not going to give you a CCD because they're not going to send you a writing admitting that what you claim is extra is in fact extra. So they're going to give you nothing. And they're going to say, get out there and move along the job. And you're going to argue, well, this is extra. And they're going to say it's not. And you're going to put in writing why you believe it's extra. And you're going to cite to the specifications section. You're going to cite to a drawing detail. And they're going to cite to some obscure item that makes no sense. But you can't convince them that it's in fact extra work. All right? That you can't get, despite all the back and forth writing, you can't convince them. Well, what do you do in that circumstance? Now, some of you may be thinking, well, I'm not going to do it. Screw them. Okay, so you can take that position. There's a risk to do that. So how do we protect ourselves is really what the issue is. How do we protect ourselves? So the first thing we want to do is we have to document it, right? We have, of course, and that's what the lawyer says. We always have to document it. And what does that mean? Well, after you're back and forth with your client and trying to convince them in writing that it's extra work and they're not agreeing with you, you have to then send a final writing. The final writing is a letter that says, Dear Bob, this is to confirm our conversation on Monday, in which you told me to do this work. We think it's extra for these reasons. we understand you've said that it's not, you don't believe it's extra work for the reasons that you laid out. But we are going to proceed with that work under protest and submit a claim at the conclusion of the work being performed. Now, why is it important? Hey, John, can you give me the 73? Why is it important to do that, right? Why is it important to send that document, that documentation, and I say using the words under protest? Well, because the law could assume that despite all of your back and forth lettering, correspondence, laying out why you think it's extra and they don't think it's extra, and you're going back and forth, if you just proceed with the work, the law is going to assume that they convinced you it was a base contract. So there has to be a conclusion to that exchange. And that conclusion is no, as the sub, I'm telling you right now, I do not agree with you. It is extra. We'll proceed with the work under protest, and I'm going to submit a claim. And the reason you say that is because this way they're on notice of your claim and that you're not proceeding as a volunteer. That's why you need to send that letter. It's critically important to do that. Now, some of you may be saying, well, wait a minute. Does that do that properly notify them of that claim? And the answer to that is yes, right? It is yes, because you need to make it clear that you are fulfilling and putting them on notice that you're seeking to get paid. Now, this is where it gets a little tricky. Every project manager needs to understand that claim and notice provisions in your contract. It's critically important because what a lot of these CMs are doing now is they're including what they call a mandatory strict compliance provision that says you as the sub have read this document and accept and agree that any notice of a claim must strictly comply with these terms in this manner, otherwise you've waived it. You've waived the claim. We've seen it go so far as to include language that says you are aware that there are legal principles of equity that can or get around these strict compliance provisions of prior practices or waiver. Yet you are acknowledging that you are waiving those equitable arguments. If you fail to comply, you're out. Now that is very strong language. We're seeing it more and more. I am currently working on a project at Princeton in which that's exactly what's happening to our subcontractor. And it's a $7 million claim, $1 million in legal fees. I would say 2/3 of the case is all about, did we comply with that notice? Well, we know the answer is no, we didn't. So I'm arguing all around it using fragnets of emails and meeting minutes and photographs and trying to argue everything. We're not, 1/3 of the case is on the merits. They're not even fighting that. They acknowledge we were injured and hurt, but they say we didn't comply with the mandatory requirements. So it's important that you understand that in order to avoid any claim against you for that claim. So you need to understand that. But I kind of jumped over something that you need to consider. Some of you are thinking, why am I doing that work? Am I obligated to do that work? So that takes us to the next slide, and it takes us to the next poll question, which is, John, you can get me there? Oh, here it is. Is the contractor required to perform the disputed extra work while it is in the claims process? Are you required to do it? Right? See, we have people think, well, it all depends. right? It depends. Let's talk about what that means. It depends. All right. So, and most contracts contain a provision that says you are obligated to continue work while claims are being decided. That's what they say. So to take the position and stand on ceremony that I am not going to pursue that work is going to run in the face of that, right? Because remember, the owner says you own that work and you're saying you don't. So now you have a dispute there. So are you obligated to proceed, right? We think the answer is yes to do that, right? We should proceed. In the 30 some years I've been doing this, and John's doing it as equal as time as I have, I could probably count on one hand how many times we told a client not to proceed with work under this scenario. And each of those times is when the amount of scope of work and the cost to perform that work was so high that it was essentially take out the working capital of the company. And because remember, you're going to do the work, you're not going to get paid for it, and you are going to have to, go through the claims process to get a resolution of it. And so it's on the rare occasion in which the client is taking the position, if I do the work, I'm going to go out of business, then we would tell you, don't do it. So keep your powder dry and fight the fight. And at the end of the day, we'll see whether you owe the money down the road. But right now, don't waste your working capital. If it's not going to take you out of business, we're going to tell you to do the work. And why are we going to tell you to do the work? It's pretty simple, because if you do the work, it's going to cost you whatever it costs you to do it, right? It's going to cost you whatever it's going to cost you to do it. If the GC goes out and hires somebody else, it's going to cost double, right? It's going to cost double or more. They may hold you in default. They may call your surety, right? So at the end of the day, if you're right that it was outside the scope of your work, you get paid for it, right, with your markup. If you're wrong, the downside risk is just your out-of-pocket direct costs. So you mitigate your downside risk. If they do it, now you're fighting over much bigger dollars than the work is actually valued. So that's why we tell clients, control your risk, self-perform it, and to do it. Well, all right, so let's say you do it. How do you get paid, right? What's going to happen? It's just like scenario 2. You have to keep time and material tickets. You have to be precise with the time, the hours, the equipment, and most importantly, the work that's being performed, so that we can clearly identify from the face of the T&M ticket that the work is being done is what you're claiming to be extra and not base contract. That's critically important. Just like in scenario 2, then you take your tickets, you're going to bring them to the general contractor for signature, get them signed, and you're going to have them stamped or not stamped. If they don't sign it, you send it to them, and you get that you process. Once you're done all the work, you will then assemble all of your tickets, and you will submit it as a change order request to the CM. The CM was going to reject it because they never thought it was extra, and now you have a claim. And then that triggers, you need to go to the claims provisions in your contract to make certain you understand what that process is and that you follow that process. So with respect to the changes provision, those are the 3 scenarios I wanted to speak to you about, but you'll see the general theme in the 3 scenarios. Always remember that we have control, right? You have control through the use of your fingers to accurately describe and document what you're doing in terms of extra work, that to maximize your ability to recover. It's when subcontractors fail to memorialize it in writing, have accurate job costing, accurate time material tickets, failure to provide notice of the claim. It's when all of those events occur is when the subcontractors have to relinquish claims. If they do what I just laid out in the last hour, then there's a great increased chance, as long as you're right, to get paid every dollar you owed, And despite that, and assuming that you did everything right, the thing that I just talked about, there's a risk, and that deals with releases. And I'm going to turn this back over to John. John?
Thanks, George. So George just went through an entire hour on change orders and what happens if you don't follow the rules. You could follow all of those rules and still lose all of your rights by signing your monthly payment release or a change order that has language on it releasing all your claims. So if a contract, here's a polling question, if a contractor follows all these contractual requirements for preservation of a claim for extra money, can the contractor waive the preserved claim by accepting a progress payment for the base contract work? If you could key in your answer, I kind of just gave you the answer, but see if people were listening. All right, so it appears that everyone is saying no, you can't waive a preserved claim by accepting a progress payment. The reality is that payment alone isn't sufficient to waive a claim that's not covered by that payment. But you have to beware of the language of your payment application because you can waive your claim through the execution of that application. Usually there's a page that's attached entitled waiver of release of liens, waiver of liens and claims, etc. You need to carefully review those before signing them because many times it will waive any right to payment for work performed prior to the submission of that application. Let's just go through that. So many of the documents, many of the releases include a provision that the contractor waives all claims up to the date of the payment application. So if you sign this document and you do not reserve your rights for pending change order requests, for CCDs, for any extra work that you're performing that is not accepted out, you will be waiving your right to payment. And we get a lot of calls from clients saying, what do? I have these extra items. I'm afraid to sign this release, but I don't have a choice because I need to get paid. Well, everyone on this call should walk away with the idea that there is no such thing as duress caused by a lack of payment. If somebody has a gun to your head and says, sign this, that's duress. But simply because payment will not be timely made, that is not duress. And you sign that release at your own risk. So here's a dreaded monthly release. As you can see in paragraph 1, you're releasing all of your lien rights, your stop notices, equitable liens, etc. That's okay. That's your lien right. You are doing that every month up to the amount of that payment, whether it's conditional or not. There's a requirement that there is a payment made to you to purchase that release of your lien rights. But where it gets trickier is at the bottom of this particular release. You'll see language that this constitutes a release of all debts, rights, claims, damages, and demands that you have against the contractor and the owner. So you've now stepped beyond a lien release and you've now signed a claim release. And that is a claim for anything that you ever had, now have, or ever will have against the owner or the contractor. It's language like that that needs to be avoided. So, as you can see, this has become the typical release language. There's usually an exception, but that exception is very limited. It usually deals with a release of retention. So if the owner is holding 10% retention, you're not waiving that by signing this document, but you are waiving all rights for any claims associated with delay, interference, inefficiency, acceleration, or any other impacts. That's where a lot of our issues come up, is that a subcontractor has signed one of these monthly releases. The job is a year behind, and we're being asked, okay, save this claim for us. And us trying to come up with different situations, different scenarios, different ways to read the documents to bring back to life any claim that hadn't been accepted out.
And John,
So,
if I can just jump in for,
sure,
once, everyone's the case law around the country supports what John just said, and not just in New Jersey or New York or Pennsylvania, but it's all over the country. So when we represent CMs or general contractors, and we are presented with a subcontractor claim for anything, the first thing we're looking at is whether they sign these partial releases for progress payments during the course of the job. And because 9 out of 10 times they have, right, without reservation. And that's a major concern. And just recently, I mean, just this, we got an order about a month ago that I represented a general contractor, and a sub, the job was delayed 18 months. The sub actually had damages. There's no doubt about that. And we were successful knocking out $2.7 million of claim. The issue wasn't whether the sub, in fact, incurred the losses as a result of the delay. Of course they did, but they waived them. And that's so. That language that John has up there, the typical release language, says that the release is from claims arising from the beginning of time. I mean, from the beginning of time to the date of that release. So it is a very, very powerful document. Do not take it lightly, and it's something that every lawyer on the other side, representing an owner or a sophisticated CM, is going to be the first thing they're going to look at in evaluating your claim.
Yeah, to add what George just said, I've been on both sides of that equation, and it's not fun to be the subcontractor who loses all of their claims because they've signed a release. I want you to also understand that when the project manager for the CM or the owner's representative says to you, don't worry about it, just sign it. We'll deal with it at the end. As soon as somebody says we'll deal with it at the end, you should run away from them, because you will never have the ability to collect at the end. The end is when you have the least leverage to get your money. So you sign these at your own risk. As George said, they're enforceable almost everywhere in the country. So to save yourself from those releases, it's extremely important that you increase the number of things that are accepted out of that release. So you should include a statement on your partial waiver release form that states that you do not waive and specifically reserve all claims for additional compensation and additional time for work performed. Always remember the time, because if you release that, you're impacting your substantial completion date. And the list of items, you could attach a separate page. That list of items should be as specific as you could possibly be. And if you sent a notice, and I suggest that you do send every kind of notice that you're obligated to send, that notice be referred to in the list. So let's say you were being delayed on the project due to an action of the owner that's costing you 5 days and $20,000. You send them a notice on July 1. In the list, you should write July 1 notice to owner of impact of $20,000 and need for additional time of 5 days. The more detail you can give, the better you are.
Now, John, if I may, with the way where subcontractors typically fall down is that there's a disconnect between the project manager and the accounting department from the subcontractor's office. From the accounting department, look, they're trying to get the pencil copy of the pay application in. They want to get it finalized, and they're going to sign documents presented by the general contractor in order to secure payment of that receivable. So, and many times for a lot of companies, you have an account representative in the accounting department who's signing off on these releases. So you, as a best practice internal protocol, you have to make sure that before anyone signs these releases, there's a discussion with the project manager to say, are there any claim notices that you've sent out, as John indicated, so that everyone is on the same page. So don't make the mistake of having any daylight between the project manager and the person who's responsible for preparing the pay apps and signing the necessary documents to get that receivable collected. Everyone's got to be on the same page, and that's where a lot of subcontractors fail, in that there's a disconnect and there's a lack of communication, and you don't realize that these things are being waived and until it's too late.
Yeah, we actually have one client who created a stamp for its accounting department to stamp on every partial waiver and release with a very broad exception language, so that if they can't get in touch with the project manager, as George just suggested, they can at least stamp it with that and at least raise the question, which is putting you in a better position than if you don't. Also remember that you are doing this on a monthly basis. So if in month A you have your impact and you do all the reservations, in month B, you better include the same reservations, or you will be waiving it in month B, even though you reserved it in month A. One of the big issues, and George touched on this a little bit when it came to change orders, is what if the owner rejects the additional language that you want to add into the release, or it's an electronic form that you can't modify? The key to that is to play the game. You need to put them on notice by way of a letter saying we could not revise the release, but we want you to know that we're signing this with a reservation of these particular items. That letter must be sent at the same time. If you are pushing a button to send an application, send somebody an email saying that application that we just submitted also was sent on a reservation of rights, and here is our list, or here's the attached information. Make sure that it's all done at the same time. Now, the law is not clear as to whether or not that procedure will protect your rights to payment. You should always talk to your attorney in that type of scenario, but it is clear that you will be in a better position than you would be if you did nothing. You do nothing, you automatically lose the game. So we've included a sample letter. We've had situations where this has gone a number of different steps where the subcontractor has signed the release with all of these exceptions. The GC has rejected that. Then we sent a letter saying this is to confirm that you've rejected that. And here is the release. Then we've gotten GCs coming back to us and say, hey, you got to withdraw that letter because that is saying you still have these claims. Then you send another letter that says, this is confirming that you directed us to withdraw the letter of so-and-so date. At some point, you run out of time, but again, these are simple 2-line, 3-line letters that will pay off significantly in the long run. We had one case on a prison project in Pennsylvania. It was a $350 million state correctional institute. The project was design build and was supposed to finish in November of 2015 and completed 3 years late. We had a client come to us who was a WBE contractor with no prior claim experience whatsoever. The client marked up the contract, changed different language. The PM says, okay, we're going to make all those, but just sign the contract the way it is. The client did. And of course, as the project went on, we were given these releases and the client was told, hey, it's only an acknowledgement that you've been paid. Don't worry about it. Just sign off on them. And the client just kept signing off on it. At the same time, the senior PM for the GC was saying things like, hey, don't send me any more letters. It looks bad for me. It looks bad for you. Just pick up the phone instead of putting anything in writing. The client agrees to do that, and no notices were sent after that point. And ultimately, the client were peaked at 98 laborers when they only planned on 50 and had a significant loss in excess of $500,000. They filed suit. I'm sorry, I was wrong on the 500. It's 2.2 million. And the contractor filed a motion for summary judgment based upon the lien waivers and the change orders that were signed by the subcontractor. And then the judge ruled in their favor and dismissed the claim, the contractor's claim. And the moral of the story is, as I said before, no one is your friend on a project. You need to get everything in writing. You need to preserve your rights. And if anyone ever says to you, don't put it in writing, we'll deal with it at the end of the job, we'll make it up on the next one, do not listen to them. It's not going to work out in your favor. So the keys to recovery: quantify the inefficiency, delay, and acceleration, provide notice, refuse to execute releases without preserving your rights, and do the same on change orders as well.
Hey, John, should we see if there's any questions before we move on to other critical contract provisions, whether the attendees have any questions that they've either given to, typed in or given to Monica?
Yeah, sure. given that we only have 10 minutes left and we haven't taken any breaks, it makes sense to break at this point. If anyone has any questions, please type them into the question box. We've answered a few of them during the course of the presentation. Right now, George, I do not see anybody typing anything.
If anyone's having issues getting onto the survey, please let me know and I can bring that up with Cohen Seglius.
All right, Monica, would it be okay if we stop now for the day and continue tomorrow?
That's fine. Thank you. I'd just like everyone to hit the raise hand button real quick so I know that you're still with us. I see them coming in. Thank you. And we will be back tomorrow at 9 a.m. I just do need to check these hand messages, raise hands for a moment.
Yeah, I won't sign out of the webinar until
Oh,
you
great.
tell.
Thank you.
So everybody, thank you for your time today, and we'll talk tomorrow. Monica, did you get everybody?
John, thank you. We'll see you tomorrow.
All right.
Thanks,
Bye.
John.